The recent judgment pronounced by the Honorable Supreme Court on the financial liability of the estate of a doctor accused of medical negligence before a consumer court is interpreted in the wrong way by the medical fraternity. Two important clarifications. The first clarification: this judgment is not laying down a new law. It is merely interpreting Section 306 of the Indian Succession Act 1925 and its applicability in consumer cases after death of either of the parties. In fact, the law clarified in this judgment was applied in civil courts and even in consumer courts across India for more than 100 years. The Honorable Supreme Court had probably anticipated this aspect, and hence in paragraph 63 of the judgment it is clearly observed, quote, "This court herein is only answering the question on interpretation of the applicable law," unquote. The second clarification: the discussions around this judgment seem to suggest that the law laid down would apply only to doctors. This is baseless. The law laid down will apply to all service providers, whether a carpenter, a taxi driver, an architect, or a doctor. This case was certainly about a doctor, but the law laid down will be applicable to one and all. Let us now understand the law laid down by the Honorable Supreme Court in this judgment in simple words. First, the right of the patient to sue a doctor survives even after a doctor's death. Second, the compensation granted to patients by court can be recovered from the estate left by the doctor. An estate means the property left by a deceased person. Third, only the deceased doctor's estate inherited by their heirs and legal representatives will be liable, not the personal property of the heirs and legal representatives. Fourth, this law is not applicable to personal injury claims. Law differentiates between the proprietary rights and the personal rights of every person. The law propounded in this judgment clearly excludes personal injuries of the deceased person. This aspect has always been legally contentious worldwide. The Supreme Court's judgment in Kumudlal versus Suresh Chandra Roy dead through LRs and others is an eye-opener for all: doctors, patients, media, parliament. Let us go through the facts with timelines. 1990, the patient lost her right eye after surgery and sued the ophthalmologist before the district consumer court. 2003, the district court held the doctor negligent and directed him to pay compensation. 2005, the doctor's appeal was upheld by the State Consumer Commission. 2006, the patient filed a revision before the National Consumer Commission. 2009, the doctor expired, and 2014, the patient expired before the court could hear and decide this case. Now, both the original parties were dead. 2018, the doctor's son and wife went before the Supreme Court pleading that the consumer case could not continue after doctor's death. 2026, the Supreme Court rejected their contention, and the case will now be heard by the National Consumer Commission. Friends, it has taken 35 long years after the surgery, and both the parties are still waiting for final adjudication. And all this has happened in the consumer courts, which were meant to provide speedy justice. Who is to be blamed? Who has really benefited? Should something be done? Thank you.